much for bearing with us as we had a little bit of technical difficulties. We could give a hand to our AV media team, that would be great. Our panel today is surely going to be an interesting one. It's on children have the right to identity when you have the interests of the children versus the parent versus the state. So we're going to make for an interesting discussion. The reason why we had media issues is because one of our speakers, Ms. Jordan Duplessis, is actually going to be speaking over Zoom today as she is in Belgium. So please bear with us as we work through some of these issues, but I know that it's going to be a great panel discussion. So I'm going to introduce our moderator, and we're going to get on with it and go from there. I'm going to introduce our moderator. Moderating today's panel is Mia Gradick, a 2L at Regent University School of Law, where she serves as editor for the Journal of Law and Public Policy and has been selected as managing editor and the Symposium editor for next year. She currently writes for First Liberty Institute, focusing on constitutional law, religious liberty, and parental rights cases. She's a Blackstone Fellow and will be a law clerk for the Senate Judiciary Committee under Senator Lindsey Graham. Mia has also worked for the U.S. Northern District of Texas under the Honorable Matthew J. Casimir, and has previously worked with the Heritage Foundation, the Center for Religion, Culture, and Democracy, and the U.S. Senate. Please welcome Mia Gradick.
Is this on? Oh, it's on. Great. Well, good morning, everyone. Thank you so much for being here, and welcome to our panel discussion on the right to identity of children versus parents versus the state. Today, we're tackling one of the most pressing legal and cultural questions: who has the ultimate authority over a child's identity, their upbringing, and decision-making? The parents, the child, or the state? From parental rights and education to state intervention in gender and identity policies, this issue, this debate is shaping legislation, court decisions, political discourse, both in the United States and around the world. Our panel today will explore this tension from multiple legal and policy perspectives, addressing how courts, lawmakers, and international frameworks are shaping this evolving issue. We will reserve the last 2 minutes for audience questions, so please feel free to send in your questions to hear from these great panelists. Before we dive in, I'd love to introduce our panelists who bring a wealth of expertise to the discussion. So sitting next to me is Joseph Cohn, who serves as Director of Public Policy at Family Policy Alliance and Family Policy Alliance Foundation, which is a national ministry impacting government and politics to see God's truth reflected in both the laws and lawmakers of the United States. As Policy Director, he leads FPA's policy strategy, providing legal and legislative expertise to elected representatives working to enact laws that protect women's safety and opportunities, vulnerable children and families, parental rights, and born and unborn children. Joseph has testified in many state government hearings and spoken at numerous events on these and other social issues. He also regularly hosts podcasts for FBA to inform and generate action amongst thousands of listeners and viewers. Joseph is also a U.S. Army veteran of the 10th Mountain Division. I mean, what has he not done? Where he served as an officer in the 1st Brigade Combat Team. His previous legal experiences are military justice investigations within the armed forces, as well as anti-human trafficking efforts both in foreign and domestic jurisdictions. He's licensed to practice law in D.C. and the state of New York, and he earns JD from here, from Regent Law School, and holds a bachelor's in English literature from BMI. Wow. And on Zoom, we have Dr. Georgia Duplessis, who is a legal officer with AEF International. Prior to joining AEF, she worked as a university lecturer and postdoctoral researcher in South Africa and Belgium. She taught courses on constitutional law, law and religion, international law, and legal methodology, and specializes in parental rights and the right of freedom of religion or belief. She's also published academic articles on the right to freedom of religion or belief, religion and education, and the right to life in journals such as the Journal of Church and State, Human Rights Review, and the Journal of Religious History. She's also the author of the ADF International White Paper on Parental Rights. So please welcome these great panelists. So the first area that I want to talk about broadly is just the large scale, the large picture here. So the first question we have is from the the United States perspective, and we'll be first talking to Joseph. So Joseph, can you briefly explain the recent disconnect between the historical approach in the United States, where parents have always held the fundamental right to rear their children, and the growing trend where the state or the child is granted more authority to make these decisions?
Thank you, Nina. Thanks for your introduction, too. And just first things first, the Bible says that you should give honor where it is due. So I just want to take a second to honor Lingo and the faculty and the staff for the Journal for Global Justice for having me up here on your platform. It's entrusted with your time. I want you to know I take that very seriously, and I hope that will be reflected in my presentation or my answers to Nina's questions. And just for the record, that bit in my bio that she read about my anti-trafficking work, that began as an intern for the Center for Global Justice here when I was in law school. So this is really a humbling moment for me to be back here and be entrusted to talk to all of you. And I'm getting back into the trafficking sphere with how FPA's work is expanding. So I'll mention that later on. But to your question, so that's a great first question for us, Dan. And this, I would say, this erosion of parental authority has really been at work for generations. So, for example, you have a lot of states that have lowered the age of consent for abortion procedures. Virginia is one of those where we sit. And I see that generational erosion as an outworking, or I see it really through the lens of cultural Marxism, which has long advocated for what they call, to the phrasing, a long march through the institutions of the West. So Marxism's foundations explicitly target the family as one of the primary authority structures that individuals need to be emancipated from in order to achieve true collective liberty. And there are multiple ways to do this through policy and culture, and granting children more sovereignty over their own upbringing and reducing parental authority is one of those core ways. So the ideology behind what I'm trying to say is a posture inherently against parents and their authority. It's a way of manipulating children to create a backlash against parents who are simply wishing to protect their kids. And the answer, I'll give you another example from Virginia. In Loudoun County, before the last gubernatorial election, there was a big, really tragic, shocking case of a student at the local high school there who was sexually assaulted in 2 separate women's bathrooms by a male student who identified as a woman. And at the school board meeting immediately following this, a concerned father spoke up to question him about it, and he was tackled by law enforcement, put in handcuffs, and marched out, very public, all in the news up there. And it turned out he was right, because the school board was lying to him and covering things up as it came out later on. People lost their board positions over this and got fired over it. So that's an image, an example I want to give you of this erosion expressing itself today.
And Georgia, what are your views on this question in Europe? How does Europe need to reconcile the rights of parents versus the rights of children in this context?
Thank you very much, Mia. Can you all hear me well?
Yes, we can hear you.
Okay, thank you. It's such a great honor to be with you from the other side of the Atlantic, here from Brussels, from Belgium, close to Brussels. And thank you so much for the introduction. If you, on our ADF International website, I recently wrote a book on, a white paper on the rights of parents from an international law perspective and an EU perspective. So if you want to know more about the international perspective of parental rights, please go on our website, it's freely available. We also have hard copies, I can always send them over to you. But from the international law perspective, I will talk up to interchangeably about the European level, and then about the international law level. Now, firstly, at the European Union level, we are 27 member states across Europe, and family law is seen as a national competence. So the European Union won't legislate specifically on the family or the rights of the family. There shouldn't be any law at European level that dictates to member states how their laws on family or parental rights should look like, although the EU has attempted to do so in different ways. So mostly at European Union level, the emphasis is on the protection of children. And mostly of parents that form part of LGBTQ communities. So parents-consensus relationships where they want to adopt a child, or where the biological parent and the non-biological parent both want to adopt a child together. So at EU level, that's where the focus on parental rights is mostly focused. But we do find again protection for the rights of parents, the European Convention on Human Rights, is right to respect for the private and family life, and also the protection of the rights of parents to guide them or to educate and teach their children in conformity with their own religious convictions. However, and then going to international law level, there is a stronger protection for children's rights, but also protection for parental rights in the family in the Universal Declaration of Human Rights and various other conventions. Also, in the Inter-American system and the African regional system, the family is seen as a natural and fundamental group unit of society, and parents are the primary caretakers of their children, and the family should be protected. However, we have seen internationally that the expansive interpretation of children's rights in the Convention, incorrect expansive interpretation of children's rights in the Convention on the Rights of the Child, has completely distorted the understanding of children's rights and alienated them from their parents. We see this, for example, in the way the Committee on the Rights of the Child. So the Committee on the Rights of the Child is the United Nations expert body that they're tasked to interpret the Convention on the Rights of the Child. And they have interpreted the Convention far removed from its actual text, and they've interpreted the scope of the rights of children so expansively and innovatively. For example, the best interest of the child, that the state is now portrayed as the child's primary representative and educator, and the entity that determines the best interest of the child. This eliminates the parents completely, and the rights of parents as well. Committees like this have also overemphasized the autonomy of the child, and now the child is seen as holding individual rights against the family, which that was never the intention of the Convention on the Rights of the Child, and holding these individual rights then imposes obligations on the parents and family by the state.
Thank you so much, Dr. Duplessis, for that. It's great insight on that issue. So the next topic I want to talk about is some parental rights versus city policies, and I'm going to ask for the United States perspective on this. So it seems that one side of the political spectrum advocates for parental rights, including a say in what type of education is taught, respect for religious beliefs, and homeschooling, while another side supports governmental intervention in education and children's participation in gender ideology. Joseph, where do you think the line should be drawn? When can the state step in and overrule a parent's decision regarding their child?
Okay, so as you all know, parents have the right to directly bring in their children. I would say to address that, where that limit lies, that line is parental rights generally end where harm begins. So a parent is presumed, as many of you know, to be acting in the best interest of his or her child, and that presumption could be rebutted by clear and convincing evidence of abuse, neglect, or abandonment. I think we're starting to see a bit of an effort to redefine exactly what those terms mean. So when it comes to gender ideology and transition, I know we're going to talk about pornography later. I'll state the reason for that for them. The question that needs to specifically be answered is this helpful or harmful? Is quote-unquote gender affirming care, or GAC, as people are working this field term. Is it harmful? So that's not a question, but what you also understand is that's not a question that any lawyer, either elected leader, or any lobbyist, or any minister for that matter, can answer. It's not satisfactory for our culture, because we're in a post-Christian moment. So the only people that can answer that in a way that's satisfactory for our culture, and could bring the receipts on it, are scientists and the doctors. And they are hotly debating this. So that is what I want people to know, what I want you to hear from that, though, is that you're going to argue policy, you're going to argue cases. Ultimately, the deciding question is really not up to you. And this should re-emphasize to you the importance of science. So I love one of Regent's newer taglines, or all those taglines are solutions to change the world. I love one of our newer taglines, which is reason and faith. Reason standing for all knowledge, including science. There's been a recent effort in history to pit Christianity against science. Science is our friend when we're trying to articulate the biblical truth. Science is constantly catching up to the Bible. and to the truth that God has given us. So, for that reason, I can definitively tell you that the scientific trend is overwhelmingly moving towards the notion that quote-unquote gender-affirming care is harmful for kids. And not just for kids, but for everyone. And pornography definitely is too, and I'll save the reasons for that later. So, for parents, I would say the focus should be on just being involved in your kids' lives. You should be quizzing doctors, counselors, school administrators, etc., all these people on where they stand on these issues, and know the good counselors in your community that actually share your values. You know who can be really helpful in this regard? Is your local church. A local church can figure out who are the counselors we know that can that really share our values, and that the parents and families and our congregations can actually trust. Because if you don't know for sure that you can trust the counselor of your kids, and particularly the school counselor, you could be inadvertently creating the initial piece of evidence that will eventually lose you custody of your kids in litigation. I know we don't have time to cover it earlier, but we skipped it, but I want to make sure I give you the name of the case to look up, and I think is represented here. You can find a great summary of it on the website for the Beckett Law Group. It is MC&JC versus Indiana Department of Child Services. MC&JC versus Indiana Department of Child Services. It was just a case where a Catholic family lost custody of their son, who was transitioned to being a woman, and they applied to the Supreme Court. They lost at every state level, and their cert petition was rejected with no comments by the judges. So it's kind of, we'll talk more about it in the Little John case, but right now, I would assume that that's the precedent, if not officially, then implicitly, is that this can happen and parents can be found abusive if they don't affirm a child's new identity. And so it would be very helpful for you as the next generation of lawyers to be clear on that. And just real briefly, Mia, I might want to just address the way you framed that question. If we believe in parental rights, then parents shouldn't just have a say in their children's education. They should have complete control over it. And for the most part, that's true. But most parents don't know that, which is where you as young lawyers come in. So, for example, most parents, I can testify to this, they don't know that they have the right to review every lesson plan in every aspect of public and private school curriculums for their children. Generally speaking, you need to be equipped to tell them that. And the logic of that is the great basis for a public policy movement called the school choice movement, which we at Family Policy Alliance and Family Policy Alliance Foundation support. The logic is really simple. If you as a parent should be able to direct the upbringing of their children and have complete control over their education, and if your tax dollars are supposed to go towards helping to pay for your child's education, then it makes sense that you should be able to direct those tax dollars to whatever education you, as the parent, knows best for your specific child. Because it's a presumption that parents know their children better than literally anyone else. So school choice simply says, if it's passed in your state, as it has in our southern neighbors in North Carolina, that you can direct your educational tax dollars to whatever school your kids go to, whether it's public, private, parochial, charter schools, and that generally returns the education to the free market and creates competition with everybody, including public schools. So public schools benefit from it. So that logic is really unassailable, and it's very bipartisan. We're seeing this unstoppable tidal wave of school choice legislation, which is great. It's only a matter of time until all 50 states pass universal school choice, and we have a school choice mandate in the federal government as well. So I think I'll stop there for now.
In fact, speaking of litigation, in light of the recent Little John decision by the U.S. Court of Appeals for the 11th Circuit, and that's where the court ruled against parents who alleged that a Florida school district facilitated their children's gender transition without their consent. How do you think that we should navigate the balance between parental rights and a school's role in supporting its students' gender identity?
Yeah, that's important. We should talk about the Little John case here. So, just last week is a case called Little John v. Leon County. Did anybody watch the president's non-State of the Union speech 2 weeks ago? Anybody watch that? Oh, you guys are good law students. You're too busy to watch those things. Well, you might remember a moment where the president recognized a mom who, the way he described it, she had rescued her daughter from gender ideology. This woman is named January Littlejohn. She was one of the plaintiffs in this case. And about a week after that State of the Union address, on a very important day in the Capitol called Detransitioners Awareness Day, this ruling was released in which they lost in a panel ruling in the First Circuit. And Little John versus Fremont County, they simply ruled that the school did not act so egregiously so as to shock the conscience when they facilitated her daughter's gender transition, social transition, to the opposite sex, started calling her by they them pronouns and a new chosen name. I'm so glad I'm here to talk this today because I was just, I'm friendly with Miss Little John, and I just saw on her Facebook post this morning the senior pictures of her daughter in high school, who's this beautiful young lady about to go to college. And if you've seen what happens when a case of this goes all the way, because her daughter's the exception. The stats show us that almost every student who begins down the path of social transition inevitably falls through with full physiological transitions, that's puberty blockers, cross-sex hormones, and the actual surgeries, the sex change surgeries. Her daughter escaped or was rescued, and I thought when I saw her pictures, what had happened. So all that to say, Little John sued Leon County School Board for this, and they lost. They lost because of some really flawed legal reasoning. But again, one of the things the court focused on, and I talked about the ultimate question is this helpful or harmful, is that what the school did was not done willfully or maliciously and with an intent to injure the child, but rather in an effort to help her. So it wasn't even enough that the question was, is this helpful or harmful? The school believed it was helpful. Now, I think there are a number of other issues with this case. I mean, where they could go from here is they could apply for an en banc hearing, which means you get the full panel of judges on that circuit, or they could apply for a seat to the Supreme Court. You'd probably choose one or the other timing-wise. I did talk to the general counsel for them yesterday, so I'm not going to tell you which way they're leaning, but those are their options. In the meantime, what I can say is that you should consider this ruling as precedent as well. So school workers who want to do this to kids without parental knowledge or consent are going to be emboldened to by this decision. So it's kind of open season for social transition, which is a non-neutral medical intervention. If you really believe in the parental right to bring their children, that is historically always included in medical decisions. You have instances where schools can now engage in medical interventions with their students without parental knowledge or consent. But those schools are probably also not qualified to do that. And yet the law has licensed them now to do it. So this ruling is going to take us in one of two directions. You're either going to go to SCOTUS and they'll review this, I think, very flawed legal reasoning into line with that standard of parental rights, and that would be great. But if they don't, then I think you're going to see the final nail in the coffin of nationwide parental trust in public schools, which is already on spectacularly shaky ground because of COVID. COVID taught parents that schools and teachers really don't care much about their students, which is sad. Another thing school choice could help us fix. So I think that's where we're going to go with this. But just I want you to be aware of that state of play now. Schools can do this without parental knowledge or consent.
Now, Dr. Duplessis, how does the EU approach this issue? When can the state step in and override parental rights, and what are the limits within the member state?
It's a difficult question to answer from an international law perspective, but there is no one legislation in international law or in the European Union about the gender transition of children and what schools are allowed to do and what the rights of parents are. It will really vary from member state to member state. But the European Court of Human Rights, it has decided before that line where children can be removed from custody from parents, for example, would be cases of neglect and abuse. And this is where I just want to agree with Joseph as well about that's where science really comes in. And that is the most objective tool that we have to prove cases of neglect and abuse. Now, the problem is that some parents would say that it is neglect and abuse not to allow your child to undergo gender transitioning. However, the Dutch protocol, which was the protocol upon which gender-affirming care is based, it has not been replicated anywhere. They've not been able to replicate this kind of positive effects that they claim in the Dutch protocol. And so the scientific evidence for the positive effects of gender-affirming care does not exist, and that's why countries like UK, Finland, Sweden, Denmark, and Norway in Europe, they've all started rejecting the giving of puberty blockers as well as the Dutch protocol, and question the scientific accuracy of it, because they've not been able to prove it, they've not been able to replicate it. And so for that reason, science is our strength here. I just want to repeat that as well, to prove neglect and abuse, and also to counter this argument that parents should have the right to let their children undergo gender-affirming care. Because the science is not on their side. The science says the opposite. So that is mostly from the European Union perspective. Countries have been, from the Nordic countries especially, rejecting the gender-affirming care. However, sadly, we do see in countries like Switzerland, a case that Aid International is specifically working on at the moment, is a case where a child has been, a 16-year-old girl has been transitioned by the school and by lobbying groups, interest groups, and without involving the parents. And the parents were actually told that they should not obstruct their child wishing to undergo such procedures. So we've seen this, and the parents have lost all rounds in the domestic legal system, in the domestic legal courts. So that is one, for example, in Switzerland, there are problems in this regard. In Scotland, there's a bill that says that prohibits conversion practices, and it says that parents should not be controlling or put pressure on their children regarding views on gender or how they dress, etc. So that can be seen as a conversion practice and actually criminalizes the behavior of parents in those instances. And then we see other examples like in Belgium, where there's the teaching of, which I think kind of also forms the bedrock of gender ideology and gender transitioning. There's the teaching of comprehensive sexuality education that includes lessons on gender ideology, and it's given to children without the knowledge of parents or the inability to opt out from these classes. So we don't see anything overriding law, but we do have in international law, but we do have some cases in specific countries, but in general, many European countries are rejecting gender affirmative care as proposed by the Dutch protocol. Thank you.
Thank you. And back to the United States, and while we're on the topic of gender affirming care, this seems like a perfect time to talk about gender transition surgeries. So Joseph, in the context of the United States, similar tensions are seen in the recent case of U.S. v. Scrimeti. Can you explain that case and discuss its potential implications for parents and children's rights?
I'd love to. So, U.S. v. Scrimeti is a big case for the country. It will probably be the last case the last ruling the court drops in June, because it'll be controversial. But it's really important to the movement that is part of it, and to us specifically, because back in 2017, we identified this, we saw as a problem, because we're a biblically based organization. We believe that God didn't make any mistakes when he made each person. God doesn't make throwaway people, he doesn't make people in the wrong body. So we saw this problem of a growing trend of what was now called gender dysphoria among adolescents. And we drafted the first model policy to protect kids from the actual physiological interventions when it comes to transitioning. So we've talked about social transitioning already. There's a lot of First Amendment issues with that. But we decided back in 2017 we're going to tackle at least the medical side of it, which is puberty blockers, cross-sex hormones, and gender transition or sex change surgeries. These are like vaginoplasties or connectomies or double mastectomies. So the laws prohibit that, and it does that by the time it was really hot. It still is PRA, it's private rights of action, because the Texas legislature had just passed a heartbeat bill that was enforced by private right of action, and that prevented it from being enjoined, and made it much more durable while the inevitable litigation ensued. And of course, they didn't foresee the Dobbs decision when that happened, so eventually Texas's trigger law went into effect once Dobbs came out. But that was a notice to all of us in the legislative draft, and hey, PRAs can work, and they can help keep your legislation victim-centric, because our entire point with health and harm. We drafted a model health and harm bill designed to allow victims to be able to gain restitution and as much justice as they could from the medical professionals that do these procedures to them. So that was first drafted in 2017. It was pretty much only us, Brian Anderson and a couple of Heritage Foundation people who were talking about this issue back then. They were all called kooks, expecting a problem. So fast forward to now, 24 states have passed that law, including Tennessee. And that's the law that's at issue in the U.S. Committee. So the oral arguments back in December. This is going to be a landmark case to determine this. And we thought that the other side, back then the Biden administration's department, the Biden administration Solicitor General, and the ACLU, who was allowed to come on as co-counsel with the government, we thought they were going to argue parental rights, because they always argue parental rights in the legislatures when we advocate for these bills. It's always, well, you guys love parental rights until we want to transition kids. Like, yeah, it's the harm thing. But, so they didn't make that argument before the court. They made an equal protection claim, which even some of the best legal minds I knew were trying to sort through. You guys probably have a lot more than I have. But what I want to draw out is they didn't do that, which is really significant. They didn't make that parental rights claim, probably because they know it's a loser at the end of the day. They know this harm stuff is where the line is, and they know that the jury's still out, at least in secular culture, about whether this is harmful or not. So what I want to mention is that this is kind of borne out when Justice Alito, in his question, he very cleverly questioned the ACLU attorney, a man named Chase Strangio, and got Mr. Strangio to actually admit that there is no research that shows that these procedures reduce self-harm in gender dysphoria cases. There's none. There's research that purports to show that, but if you dig into the methodology in each of those research projects, the scientists in here, if anybody did science majors in undergrad, you'll see how methodologically flawed those are. And more importantly, every systematic review of the evidence, which is a holistic review of multiple studies, has shown no positive benefit or reduction in self-harm. So a lot of research is showing that. Justice Alito called it out and made sure to get it on the record. Now, that was fascinating. So this committee will probably come out in June. It could come out any time. But it's a very important case for this overall movement, really for FDA. We're hoping to get vindication that this law that we drafted has always been constitutional.
Thank you so much, Joseph, for that. So while we're on the topic of gender, I think an important thing for us to discuss now is state intervention in gender transition treatment itself. So I'm first going to turn to the EU perspective. So Dr. Duplessis, are there member states in the EU that are requiring parents, emphasis on requiring them, to allow their children to pursue gender identity changes? And does the EU support a right to identity for minors? And is this addressed under the Convention on the Rights of the Child or any other similar frameworks?
There are a few governments that I've already mentioned. For example, Switzerland, the case we have there, that Switzerland is not part of the EU though, but still in our case, they've expected from the parents to allow their gender transitioning. And then I mentioned the Scottish bill as well on conversion practices where so-called controlling or pressuring parents can be guilty of a crime where they direct their children to not act in a certain way or in accordance to a certain gender identity. But most of the EU member states don't have legislation that kind of requires parents to allow children to undergo gender transitioning. In most EU member states, they will only allow, for example, sex reassignment procedures after the age of 18, or subject to the normal requirements of surgery where parental consent is required. Now, I've mentioned some exceptions to this, but even as I said before, even if a parent consents to such surgery, states should, even if they don't, should block this gender-affirming care or transitioning because of the lack of evidence and the lack of replication of the Dutch protocol. In medicine, parents can consent to treatment and procedures well proven in medical science and well established in practice, but gender-affirming treatment and the Dutch protocol has been shown to be experimental, and it will be actual neglect and abuse to expect for parents to allow their children to undergo these gender transitioning surgeries or care because it's not proven medical science, it's experimental. And parents in medicine cannot consent to procedures and medicine that affects, that has risks attached to it, risks that are unknown. And the same goes for gender-affirming treatment, puberty blockers, and gender reassignment, or procedures of that sort. Now, at international level, for example, there is a right to identity in the Convention on the Rights of the Child. But that mostly concerns a right to identity as it relates to nationality, name, family relations, and it has not been interpreted as a right to decide on matters concerning gender transition, or a requirement that parents should allow their children to undergo gender transition. However, there has been problematic, as I said earlier, so-called experts, United Nations experts, that have interpreted the autonomy of children so expansively that it can lead to such assumptions. Now, these opinions of these experts are not binding, but it creates some kind of soft law that puts pressure on the member states. For example, I will give you one of the special rapporteurs of the United Nations, the rapporteur on artificial intelligence and privacy. I will quote one of his reports, where he says, and I quote, as they mature, children desire and require privacy not only from schools, but also from their parents. And then he says, sexual expression and physical autonomy are part of the interwoven fabric of children's privacy, and this means that adolescents need to be able to safely and privately explore their sexuality as they mature. And then he states governments, then he states that this autonomy is infringed by governments, healthcare, other professionals, parents, and peers. So thereby completely removing the child from the care of the parents and the sexuality of the child from the authority of the parents. And as I've said, so in international law there is no such right to identity, but some of these experts have interpreted such an autonomy right that is not beneficial to children on parental rights. Also at the European Union level, there is a right to identity, but the courts have only interpreted that right when it comes to gender identity to apply to adults and not to children. So at a binding level, at international law level or European Union level, there's no binding law that can expect this from parents. Thank you.
Thank you, Dr. Duplessis. The next area that I want to discuss is parental secrecy acts. And so we're first going to look at the United States. So recently, several states like Nebraska and Washington have introduced legislation that aims to protect parental rights, such as requiring age verification and parental consent for minors to open social media accounts or revising parental bill of rights in schools. How do you view these state-level initiatives? Are they necessary safeguards, or could they be seen as governmental overreach?
Yeah, I know the people that are arguing against government overreach are usually not the people very concerned about government overreach. And in fact, we in a legislative hearing in Nebraska last year. So there are two issues that you mentioned with this really good question. One is protecting kids on the internet, and the other is parental rights being reasserted in schools. So I'll just go one first and the other really quickly. So this current state of play is that 21 states have passed laws requiring mandatory, safe, age verification procedures to access adult content online, which we colloquially define as pornography. These are sites like Pornhub and Xvideos. Those are the two biggest sites. And then, let's see, 4 have also done that for social media, so requiring age verification opening accounts. And then just recently, Utah passed what I and our coalition and work with the national groups believe is the most elegant solution to protecting kids online, which is an App Store Accountability Act. We're going to talk more about that later. So I'll just talk more about the need for these right now, because the answer ultimately is yes, these are really critical bills. So if we stay focused on the question of harm, it's much more definitive when it comes to the areas of social media and online pornography. The debate on both of those obviously is really over. There is no more debate. We know those things are harmful to kids, particularly post-pandemic. So unfettered child access to these is definitely a violation of parental rights because of the harm this does to their kids and other aspects of parental rights. So I'm about to blow through some research, each point of which you would rightly want to pause and think about. I'm sorry I don't have time to linger on them, but here's the reality. Most kids are first exposed to pornography between the ages of 7 and 13 years old. 7 and 13. Most of that exposure is unintentional. The kids are not looking for pornography, the pornography is looking for them. That is how the internet works now, because they have developers structure their apps and their marketing of it specifically to take advantage of underdeveloped brains. And within those apps, most of that first unintentional encounter with pornography happens within those apps, specifically because filtering does not apply within the apps. So I like to use the example of Snapchat. Pornhub is 2 taps away with Snapchat. You open Snapchat, that first tap doesn't count. You tap on a snap, and then just like an Instagram story, you can put a little banner with a link in there, the link of which you can customize the text. So you can see innocuous, child taps on that, and they're in Pornhub, no matter what filters are on the device. We further know that most kids are having this first exposure before the age of 18, and that they are actually believing the lie that the sex trade on places like Pornhub is an accurate portrayal of sex. And we also know from the research finding that most videos on Pornhub and X videos that showcase some kind of abuse. It's either verbal or physical abuse. It's usually both. And we know that it's actually believed that's what they think sex is. So that's where they're getting their sex ed from. And a parent's right to direct the upbringing of their children is supposed to include when and how they learn about physical intimacy. But that right is being completely abrogated by everything I just told you. If all that is true, that kids are learning about sex through exposure to porn without parental knowledge or consent, then how can we say that parental right is secure? So these rights are essential to doing that because now, so in a state like Nebraska, where I went there and advocated for the social, or for the 80 for Porn bill last year, if someone tries to open a Pornhub there, well, actually, the way it's supposed to work is Pornhub is supposed to cycle you over to a third-party site that securely verifies your age without retaining your data. If you're over 18, and send you back to the site and make more money. If it doesn't, it's supposed to block your access until someone they establishes a parental relationship with you and lets you in. I challenge you to find any parents who's going to let their child watch Pornhub. I'm sure it exists. The point is it's not the majority. Unfortunately, what's actually happening is in these states, I think 18 of them, there's 2 states who just enacted them, so Pornhub hasn't had a chance yet. They've actually pulled their business entirely from the state, which is not just an advocacy statement, a legislative advocacy thing, it is a moral thing. They are saying we think it's a positive moral good for kids to be able to access pornography without parental knowledge or consent. Kids can't have porn, nobody can have porn. So that's the parents' compromise. What they need is the classical notion that governments should support, partner with the parents to reassert their right to be the primary protector of their kid. So our hope through these laws is that it will restore the chance for kids to get age-appropriate sexual education, preferably from a parent or guardian, and as Christians, preferably from a biblical worldview. So that's the problem when it comes to the internet. We're going to talk more about the App Store Accountability Act in a minute, but also there's some contractual concerns there. But just also when it comes to, you turn to parental secrecy laws, Mia. So we call these parental notification laws. Just so again, this is what our framing could be really important. What we mean by that is something like the model SAGES law, which has been introduced in Virginia for the past few months, or past few years. What they simply require is that if a child expresses to anyone in the school some kind of discomfort with who God made them, the schools have to immediately notify parents of that and get them involved. So I would say opposition to those are really a continuation of that Marxist ideology that I mentioned earlier. There's nowhere that ideology has gone farther than along the margin in public schools and teacher sheets. And these entities openly, generally consider parents an enemy in every aspect of a child's life, particularly when it comes to educational and medical decisions. I want to make sure I'm clear. There are a lot of great selfless teachers out there who are forced to be involved in these unions, otherwise they can't teach. So I don't want you to have the eye of suspicion towards every single public school teacher out there, but use your judgment as a parent. And I think I want to say, let's see, that's why these laws are really important. And I'll just leave you with this. It's kind of ironic that the primary places where this parental authority over medical rights is being muddied is regarding, I mentioned abortion earlier, and gender transition. Like, why have we only muddied parental rights in those 2 areas? They're probably not just, those are the 2 most culturally significant ones. I think you guys are smart enough to draw some implications from that, especially since I haven't even talked about how HIPAA is regularly misrepresented by healthcare professionals for when parents can get involved with kids at actual medical appointments. So the only thing I would say to you there is, as future lawyers, you need to be prepared to consult with parents about what HIPAA actually says and doesn't say, what it actually means for them and doesn't. Because there is no circumstance under which a doctor should be able to tell a mom, can you leave while I meet with your underage child? There's no circumstance in which that should happen. That happens all the time. Because no one knows what it says. So be prepared to talk with your clients about that.
So on the EU perspective, I'm going to rephrase it now after what Joseph just said. So are there any parental notification laws or similar policies being proposed or implemented in the EU, particularly regarding issues like gender identity or mental health in schools? Dr. Duplessis.
Thank you. At EU level, there's no such parental notification laws or actually stopping parents to know information about their children or withholding information about their children. Or also, in general, parents are notified about healthcare matters concerning their children, and school policies allow for that. We have seen exceptions, as I mentioned, in Switzerland, but there is no, actually, the European legal framework would support the involvement in parents concerning healthcare matters. However, with regards to tools like age verification tools, so we have the Digital Services Act at the European Union level, and they're in the process of implementing age verification tools on large online platforms like TikTok and X. It's been quite controversial in the US as well because the Digital Services Act regulates illegal content and includes hate speech. So there's some concern that it overreaches free speech. But in terms of protecting children, they are in the process of implementing age verification tools. And then we have, for example, GDPR rules, placing restrictions on the online processing of children. And then also another proposed regulation, it's not accepted yet, is on child sexual abuse. But so this regulation will allow for electronic communication services, chat and services, to where there's an automated scanning of everyone's private communications to see if there is any imaging or something concerning child sexual abuse. The problem, the pushback that the EU has gotten for with also the Digital Services Act and this regulation of child sexual abuse is that it can violate privacy rights of parents actually, and also of the child. But these are the tools that the EU is in the process of putting in place. Some of them are partly in place, but not fully. But there is very little at EU or international level about parental notification laws. It's mostly per member state.
So we're going to shift gears. We have about 10 or so minutes left before we open it up to questions, but I wanted to cover two different areas briefly and hear from both of these panelists on religious liberty, and then we're going to discuss digital age. I just sort of wanted to showcase where we're going. So the first question that we're going to ask is about religious liberty for the United States. So religious liberty has long been considered in parental rights discussions, particularly with cases like Wisconsin v. Yoder or Pierce. Are there any new legal challenges or trends in the United States that might threaten or redefine the scope of these legal rights? How do you see the intersection of religious liberty and parental rights evolving, especially in education and state policies?
You want me to start? Okay, so thanks for that. That's a great question. I have just two things. I have one case for you all to watch, and then one philosophical notion to consider. So there's a case that the court just agreed to hear, I guess, called Mahmoud v. Taylor, M-A-H-M-O-U-D, Mahmoud v. Taylor. And I believe actually that person was Roth and Dean Walton submitted a amicus brief on this, so thanks to them for doing that. We sent on to another amicus brief. I think Becky Law, our lead counsel for this case, so you can find it somewhere on their website. But basically, it's a very religiously diverse group of Maryland parents. It includes Muslims, Catholics, Orthodox Christians. They're suing the Montgomery County Board of Education for forcing their pre-K and elementary age children to read controversial books that promote a one-sided transgender ideology and encourage gender transitions, things like that. And they're just asking A to be notified when those are going to be read, and then they're asking for an opt-out. So they petitioned the court for that. The court's going to hear it this term. That might sound to you, at least on its face, like a parental rights issue, and it is. But what the court has signaled is that they're going to review this as a free exercise issue, which is good too. This is a very diverse religious group of parents. But it's also reflective that the court is continuing to dodge these challenges to parental rights from special interest groups. We've mentioned a lot of people are most culturally aware of, but the court, between this and the Cox case, the Little John case, if they don't grant cert, people really need some, parents in America really need some clarity on where their rights intersect with these special interest groups that we're contending with. So watch my movie Taylor, probably going to be free exercise. I hope it includes parental rights. And I just want to think about this new concept of rights. And Professors Dwyer and Gillis really set us up well for this, so thank you for that, gentlemen. They set us up for something I'm going to offer for y'all to think about. There's this new argument taking shape. I see it mostly on the right of conservative America, and it argues that children should have a right to certain things, like a right to a mother and father together in marriage, or a right to a healthy diet. There's a lot of talk about that. Now, these obviously sound really nice ends, and I'm personally quite in favor of that. I'm just skeptical of the framing. So I like the end goals there, because I think if the research shows inevitably that mother and father together in marriage have inestimably better social outcomes and are benefited by that. So I like that end, but the formulation I want to highlight of those rights is really not in line with America's traditional understanding of rights and formulation of rights. So, for example, classical rights formation, as we heard a little bit about earlier, does not require anything from anyone. So if the government never does anything, it will not violate, for example, my right to free speech. I can talk as much as I want. As long as the government does nothing, it will not violate that right. So the government has to positively do something, right, in order to violate it. Think about the Dobbs standard here, as future lawyers. A right has to be deeply rooted in the nation's history and tradition of ordered liberty. That's the formulation that we've got. That's what's good law. So what we're seeing now more and more is an inverse framing. This used to be entirely on the left, by the way. I'm seeing it more on the right now, but you really heard it from the left for years, which is, for example, I have a right to an abortion. A right like that requires action from other people. That right cannot vest unless a doctor sits down with a team of healthcare professionals and performs the abortion on the woman. It requires that service from them, a service that required years and years of training and hundreds of thousands of dollars to pay for at that individual's own agency. So if we start formulating child and parent rights in this context, we're going to start demanding things from adults, perhaps against their will. And I think all of you are smart enough lawyers and future lawyers to understand just how dubious that could be. So all that to say, this is an important discussion, which is where I am grateful for that framing, because it means we're starting to refocus on kids. If for so long kids have been just steamrolled by the law, by politics, by our culture, they've been put second to adults. So the framing is helpful in reviving that discussion. I'm just skeptical of where these new ideas of rights will take us.
And now, Dr. Duplessis, there has been a similar ongoing debate about the intersection of religious liberty and parental rights in the EU. Are there any legal challenges or developments regarding this issue?
I will mention the ongoing challenges that we're seeing. As mentioned, the right of parents to raise their children in line with their own convictions this right is well protected in Europe and in international law and other regional systems like the African system and the Inter-American system. But in practice, we've seen in Europe that it's been more turbulent than just the states implementing, or the European Court of Human Rights accepting or implementing this right with sufficient recognition of the rights of parents. We see that in school curriculum and in opt-out matters where the court has, for example, in the case against Norway, it has allowed atheist students to opt out from a course containing elements of Christianity, but in Germany, again, Christian students were not allowed to opt out from even leading to the imprisonment of the parents who withdrew their children from these classes. And then also, for example, there was one case in Switzerland where 2 Muslim girls were asked to be opt-out from compulsory swimming lessons with boys. They were still in primary school. And the European Court of Human Rights refused to find in favor of these 2 Muslim girls. And actually, their reason for asking opt-out was because of their sense of modesty. They didn't want to be in bathing suits in front of boys. And the European Court of Human Rights agreed with the Swiss government saying, but they actually have to socially integrate, and they have to be, and they use this wording, they have to be used to seeing half-naked bodies in the society. In this case, the court hasn't really considered parental rights very well and their right to raise children in line with their own convictions. For example, on issues like home education, there is no EU-wide regulation on home education, but we have a very different member state application of something like home education. It varies from member state to member state. For example, Germany is very strict. They prohibit home education, and we actually have what they call home education refugees, where persons flee from one country, or parents and their children go from Germany to Italy, for example, because they want to home educate the children, but in Germany they will be prosecuted for doing so. Or even sometimes have children removed from them. We had cases of that sort as well. And we see that the European Court of Human Rights has accepted arguments such as avoiding the creation of parallel societies and social integration to allow member states to ban home education. So the United Nations, for example, actually reprimanded countries like Germany for not legalizing home education. But the European Court of Human Rights has not taken the right of parents to raise their children in line with their own convictions seriously, or given it adequate weight. Also in European law, parents are allowed to set up their own religious schools again, but member states are not required to pay or to contribute to such schools. So there is a difference between secular schools, which is also a religious school, secular schools that are paid and funded by the government, and then religious schools that can be set up by the parents, but the parents must fund those schools themselves. So we have the rights in theory, but in practice the application of theirs has not considered parental rights for them.
Thank you. So one final question for Joseph before we open it up to one audience question, because I know we're all very anxious to go to lunch and we started a little late with some technical difficulties, so for the sake of time. But let's just briefly discuss children's digital privacy. So Utah recently passed the App Store Accountability Act, requiring app stores to verify users' age and obtain parental consent before minors can download apps. Supporters say that it enhances online safety because it involves parents, while critics argue it raises privacy concerns and enforcement challenges. So does this law, in your opinion, Joseph, strike the right balance between protecting minors and respecting digital autonomy?
Yeah, we do think it does, and I think it hinges on contract law provisions. Everybody in here has either been through contract law or is currently taking it in their courses. The basic contract principle is that minors cannot consent to legally binding agreements. But that's exactly what happens every time you download an app on an app store. You're agreeing to terms and conditions with both the app developer and the actual manufacturer of your device. And kids do this all the time. So the App Store Accountability Act does, among other things, is it essentially requires that App Store developers and the actual App Store facilitators, like Apple or Google or whoever hosts it, verify the age of their user. As an underage user, they have to establish verification from a direct parental relationship with that user. And the law gets into detail about how that's done. It's very well done. So FDA is proud to support that, and the law is actually enforced in part by private right of action. So I mentioned PRAs earlier. I want you to see this as the intersection of PRAs and contract law. And so we think that's critical to it, because these kids should have no business being legally bound to any of these big tech companies, especially not without parental consent or knowledge. So we see it as essential to restoring that authority, and we've been proven right because the lobbyists we've been dealing with in this, on the other side are most of the technicals.
So that's it for all the questions that we have, but one question from the audience that I think both will be able to answer, and I'd love to hear your thoughts first, Dr. Duplessis, is, are children's rights versus parents' rights zero sum? Does more of one inherently mean less of the other?
I'll quote this commissioner, this professor, this commissioner, she says it's the same side, it's two sides of the same coin. And I really think that children's rights can only be protected by the full protection of parental rights. Because parents are closest to their children, they know their children, they know what is good for them, they know what is in their best interest. And the state is not in a position, if you look at subsidiarity, the state is not in a position to understand the child, to curate the child's best interest, and to curate the education of the child. Very exceptional circumstances, parents are neglecting and abusing their children. And in European law, even in those cases, we've seen the European Court of Human Rights eventually trying to reunify the family in cases of proven overt sexual abuse or neglect. Well, not sexual, but cases of abuse or neglect where the parent has, for example, a drinking problem or a drug problem. Even in those cases, there are attempts towards remedies, because ultimately it is understood that the parents know their children the best, the parents take care of their children the best. And therefore, I don't think it's one or the other. I think the protection of children and their rights is absolutely, can only happen when parental rights, the natural rights of parents to their children and to take care of their children are protected fully.
I mean, that's a brilliant formulation. I would completely agree with that and appreciate it. The only thing I would add is the first thing I thought of when we read the question is that I would reject the notion that it's a zero-sum game, the same way I would reject the notion that economics is a zero-sum game. My sister's a great economist. She helped me understand this. There's a notion that there's only so much wealth in the world. Wealth is fixed. And we all now know that wealth can be created. So I would say the whole point of that two-sided coin, the parents' rights and the child's rights, to promote families, is to promote family flourishing. And that's something that can be renewed and created, and is created by the security of those rights. So that's the only thing I would add.
Well, this was such a fantastic discussion, and thank you so much to our audience and for your thoughtful questions. There was a lot of them, and so unfortunately we didn't get to go through all of them. But as we've explored today, the balance between parental rights, children's autonomy, and state authority is shifting, and it's a deeply consequential issue. And I think something that I was thinking about while I was listening to both Dr. Duplessis and Joseph speak is that it reminds us that there are real families, there are real children, there are real lives at the heart of these debates with real life implications beyond the mere legal and the policy debates. And I think that reminds us of why we're doing what we're doing, the call that we have as Christian attorneys. So a huge thank you again to our panelists for sharing their time and their expertise, and to all of you for being a part of this conversation. We hope that this conversation is giving you a new perspective on these issues. Before we officially close this panel, I'm going to invite Darby up for a few moments.
Thank you guys. That was incredible. I'm the executive editor of the Journal of Global Justice and Public Policy. I'm about to dismiss y'all for lunch, but we have a few announcements. The first one is that we have two vendor tables set up also in the balcony. The first one is CASA, court-appointed special advocates, and they do incredible work across the nation, specifically with children in foster care, working to represent those children and give them a voice in the courtroom. If that's something that you might be interested in volunteering or learning more about, highly recommend stopping by and talking to our volunteers at that table. We also have Heidi is here from SBA selling regional merch, if you want to look at that. We are going to let our panelists and moderators have lunch first. What you're going to do is you're going to go out those doors and around to the right through the buffet line, and you can come back through. You're welcome to eat in here. Please talk to our panelists, moderators, professors that are here. This is a great opportunity to make friends and make connections.
connections and maybe ask them some of your questions that you weren't able to get asked during the actual panel. So I'm going to pray for us and bow your heads with me. Dear Lord, thank you so much for this time together here. Thank you for the opportunity to be at Regent Law, to speak freely about what we believe. Thank you for professors and speakers that are striving after you to bring your kingdom on earth through the work that they do, Lord. I just pray that you would continue to bless their efforts and guide their steps. That you would be over us as we are learning about these different topics, that you would show us clearly where you would have us working in the future, whether it be in these fields or adjacent ones, that whatever we do be for your glory and to further your kingdom here, Lord. I pray that you would bless this food to nourish our bodies and our bodies to serve us. In your holy precious name we pray. Amen. Thank you.